Hello, Hawaii. My name is Caitlin Johnston. I am an attorney in New York City, and I am very glad to be here with you all today. You've already accomplished so much making it to nationals. I did We the People when I was in high school growing up in Indiana and did not make finals. So you've already bested me. And I very much look forward to the conversation that we're about to have.
Hello, I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. It's very nice to see you. And again, congratulations for making it to the national finals.
And I am Edward Volpe. I'm an attorney in Denver, Colorado. I've been associated with this program for many, many years. I look forward to your presentation and to learning how well you have developed your skills with regard to these subjects.
Very good. All right. Will you introduce yourselves and your teacher, please?
Hi, my name is Francis. I'm a junior from McKinley High School, and our teacher is Mr. Sean Kamita.
Hi, my name is Byron Kim, and I'm a senior at McKinley High School.
Hello, and I'm Erwin, and I'm also a junior in McKinley High School.
Very good. All right, let's get started. You know the drill by now. We are doing question one. I'm going to read it all the way through. And when I stop talking, you can begin, and that'll start your clock. Please remember, in case I forget to tell you, to put your notes away for the follow-ups. All right, here we go. So, result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
We agree with the ruling of Wisconsin v. Yoder. Wisconsin v. Yoder surrounds 3 Amish fathers who refused to enroll their children in school past the 8th grade, even though all children were younger than the age requirement to leave school. The fathers reasoned it would be inappropriate for their children to receive this schooling because it would expose them to values that countered their religion and lifestyle. The U.S. Supreme Court ruled, while the state should continue to encourage compulsory schooling to all students, the Free Exercise Clause of the First Amendment cannot be ignored in the name of education. In a dissent to the ruling, Justice William O. Douglas elaborated that while the parents normally speak for the entire family, the child should be given an opportunity to be heard before the state gives the exemption which we honor today. And recent cases clearly held that the children themselves have constitutionally protected interests. In response to Justice Douglas, Justice Stewart notes, no facts in the record suggest that the children's religious beliefs were at variance with the beliefs of their parents. Accordingly, the children's religious rights and choice of education were not issues addressed in this case. However, through Tinker v. Des Moines, it is held that students are entitled to their freedom of expression. Otherwise, while we agree with Justice Douglas's opinion, had it been applicable, we agree with Justice Stewart and believe that the child's choice of education and religion.
On the topic of education, while a child's right to education was not addressed in the ruling of Wisconsin v. Yoder, it is protected through the U.S. Constitution. First, the Equal Protection Clause of the 14th Amendment reads, "No state may deny to any person within its jurisdiction the equal protection of the laws." This quote was interpreted and invoked in Brown v. Board of Education. It means that no public elementary or secondary school can segregate students based on race. Second, the Due Process Clause of the 14th Amendment reads, "No state may deprive any person of life, liberty, or property without due process of law." The Supreme Court interpreted this clause to have substantive protections, and through this, protect the parent's right to the child's education. In our state's, Hawaii's Constitution, the right to education is protected in Sections 1 and 4 of Article 10. Section 1 directly protects the right by stating, "There shall be no discrimination in public educational institutions because of race, religion, sex, or ancestry." Section 4 guarantees the state will provide Hawaiian education courses in public schools.
On the topic of religious beliefs, Wisconsin v. Yoder is one example of how courts balance religious beliefs. In Wisconsin v. Yoder, the U.S. Supreme Court balanced religious rights and state laws by ruling that the freedom of religion precedes state education laws. Other examples include Burrow v. Hobby Lobby and Employment Division v. Smith. In Burrow v. Hobby Lobby, the U.S. Supreme Court balanced religious corporations and their employees' healthcare accessibility by ruling that corporations are entitled to the same religious rights as individuals. In Employment Division v. Smith, the Supreme Court balanced state laws and individual freedom by ruling that as long as the law is generally applicable and does not target a particular religious practice, then it does not violate an individual's First Amendment rights.
In sum, yes, we agree with the majority ruling of Wisconsin v. Yoder. Even though the child should be given an opportunity to voice their opinion on decisions concerning their personal education and choice of religion, it was not proven that the child's interests were argued during this trial, as seen with Justice Stewart's concurring decision. This concludes our presentation.
Great, thank you very much. We will start the follow-ups. Please put your notes away. How should we analyze laws that have an impact on religious beliefs? Can you tell me about how the courts have looked at those things, those issues?
I'm sorry, can you repeat your question? I kind of lagged on this side.
That's okay. How should we analyze the laws that may have an impact on religious beliefs? You talked about a couple of the cases, but what did the court do with those? How did they reach their conclusion?
The court has ruled that if there was any types of pre-existing laws that didn't target a certain religious practice or group, then if a religion went against that law and it was brought into court, the court would usually favor the law more since it was already there.
I'd like to expand on what Erwin was saying. He's talking specifically about the case Employment Division v. Smith, and he's absolutely right. It's ruled and held that as long as a law is generally applicable and doesn't target, again, a specific religious practice or a religion as a whole, then it cannot be considered a violation or a predation on religious beliefs.
How would you square that with the Hobby Lobby case, where the general rule was the coverage of birth control under the Affordable Care Act? That's a rule of general applicability. How'd the court deal with that?
So in Burwell v. Hobby Lobby, how it was solved is that they looked up the definition of a person under the Dictionary Act. And in the Dictionary Act, it held that a person can also be considered as a corporation, that the two are interchangeable. So therefore, they entitled and guaranteed that this corporation, Hobby Lobby, would have the same rights as individuals.
Thank you.
You had said in your presentation that you agreed more with Justice Stewart's concurring opinion than with Justice Douglas' partial dissent. Do you think that the Yoder case should have addressed the child's beliefs? And in the future, how do we get the child's interests before the court? Are they going to have to sue their own parents?
In Wisconsin v. Yoder, since it did go against and it did involve the child's education and going further on with it, it did involve them. So it should have been brought into court. So for future cases that does relate to it, the child themselves should also be able to speak their own mind and be able to express their own opinion because it does involve them.
You brought up freedom of expression under Tinker versus Des Moines. Has the court allowed students to express their religious beliefs, particularly with regard to prayer within school? Is a prayer at the beginning of school over the public address system allowed, or is that an endorsement of religion?
I would say that it shouldn't be allowed. Students themselves, if they would like to talk about their religion, let me rephrase into better words. I don't believe that religion should be a specific subject or practice that is enforced by the school, because the school is the organization that teaches its kids, right? So Again, there's a lot of variance between religions and the absence of religion at school grounds. So I don't believe that there should be a prayer mandated by the school unless, of course, it's already established that the school is focused on religion. Otherwise, I feel that the students have the right to express their religion, but again, it shouldn't be enforced.
Since the child's religion is protected, whether they're on school grounds or not, it should also play in a factor as it doesn't cause any disruption in the school system, or it doesn't go in specific guidelines that the school has already established. And we see that the court case in Tigger v. Des Moines has ruled that since the students didn't cause any types of disruption with the armbands, they were protected by their right to express themselves.
I want to go back to Judge Murphy's question about whether we're leaving children, you know, in a position where they have to sue their parents if they disagree with their parents' religious beliefs. What about an ultra-conservative religion that wants to marry off young girls before they've reached the age of 18? How would you deal with that under the case law that we've been talking about?
May you rephrase that question again? Sorry, like towards the end part of it.
So the hypo is there's a religious belief that young girls should get married before the age of 18. You said that the children should have more of a say, but how do we get there? What does that look like under the current Yoder decision and others, or what should it look like?
If I may answer for this part, for children marrying under 18 years old, I'd say that it shouldn't be, I'd say legal, because whatever it's already established in as a law on how minors are not able to be married under the age of 18, yet some religions do want to push the boundaries of that law. So for their religious beliefs, I believe that they shouldn't, because it's already established and you're not allowed to break that law.
Expanding more onto what Byron has said, as long as there's no like any types of pre-existing law that would establish that any citizen can't do a specific thing, the religious group or practice shouldn't be able to go against it and defend themselves with their religion.
Thank you.
Can the state, or more specifically a school district, lawfully require that students be vaccinated against the coronavirus against a parent's religious beliefs before being allowed to return back into the school?
Well, I think that would definitely be a very tough topic to consider, because it comes between an individual's bodily autonomy and what they choose to receive versus the greater good of the school. So I think it would really be a battle between establishing, are we willing to put other students at risk for spreading or catching this disease, this virus, just because somebody would like to set their foot down based on religion. Personally, I do feel that a school can mandate it, and if they would like to look at specific cases to allow exemptions, then it would have to be clearly established that the religious belief or religious belief is legitimate, per se.
Are there any cases that have addressed a similar type of issue?
Saved by the
Not that I
bell. Saved by the bell. All right. Take a deep breath. You can breathe a sigh of relief. You guys are done. Good job. That was a fun discussion. I really enjoyed it. I thought you packed a lot into your prepared remarks. I liked the way you trotted through the Equal Protection Clause, the Due Process Clause. And I think where I was trying to go with my first question was the concept of strict scrutiny and how we study limitations that we're placing on religion a little bit more carefully. So you managed your way through the question, and good teamwork on that. And I think the other feedback I would leave you with is a couple of you did this to good effect. If you don't know the law, just start riffing on what it should be, and come out with good reasoning for why you think a certain, result might happen. I have been throwing that curveball question about child marriage all day, and you dealt with it very well. Just watching you kind of think on the spot and walking, rationalizing your way through it was fun. That is not easy to kind of answer those on the spot. So thank you, and congratulations.
Yes, thank you for your presentation and answering our questions. Some of the questions are a little bit out of left field, and what we're trying to do is to see how you think under some pressure and not with a script that you've prepared. And you handled yourselves well. Like Judge Johnson said, that when you get where you're not so sure what the sites are or what case law there is, then you can always fall back on what your position is and how you feel about it. And the question that I asked you at the very end there about the vaccine, there is case law that Judge Volpe will be able to give you, because he knows it a lot better than I, but that goes back almost 100 years, that has authorized the state in being able to mandate some vaccination. So, but good presentation. You listened to the questions and you answered them as best you could. And I really appreciate that. So thank you.
Well, I echo my prior judge's comments in that one of the things that impressed me is I felt like you students were speaking from the heart. You were talking about your feelings with regard to these issues. And I think that is a very worthwhile way to address these questions. And I enjoyed hearing what you think, as opposed to just a recitation of every single Supreme Court case that's ever come down on these issues. Because we want to know what you think about your education, your religious rights, and similar rights. Judge Murphy is quite correct in that the Supreme Court has ruled on vaccinations, one of which was Jacobson versus Massachusetts, and more recently, Zucht, Z-U-C-H-T versus King, which said schools can insist upon vaccination before a student returns. But the whole idea that the rights of students should be taken into consideration, I think, is a good one. I also thought your reference to freedom of expression in Tinker versus Des Moines and the dictionary definition, I thought those were excellent points with regard to the analysis of this particular case. You came up with Smith versus Employment Division. You should be aware that after the passage of the Religious Freedom Act, Restoration Act, the court has ruled in Gonzalez versus O.S. Spirito, that Native American churches can continue to use peyote, even though it is a banned substance, simply because they've been doing it for centuries. But with regard to those kinds of details, those are things that I think you will continue to pick up as you go along. I hope you will stay with these studies. I hope you will continue to educate your fellow citizens with regard to what you have learned. Keep in mind, you know more than most of the voting public of America. And I want you to use that for political purposes and for educational purposes to benefit your own society. Thank you for your efforts this year. Thank you to your teacher for the efforts on your teacher's part. I enjoyed hearing you.
I would just like to say thank you so much for the very helpful feedback and for being such great judges. I really appreciate you letting us take up such time out of your very, very busy days.
Thank you so much again for the comments. They're really helpful. And just for like motivating us in a sense, because, you know, during this harsh time, it is really hard for everyone here. So again, like what Francis says, thank you for devoting your time for doing all of this.
And oh,
I want
sorry.
to offer you. Oh, sorry. Go ahead. Go
Oh, no,
ahead.
I was just gonna thank everyone for just going out of their way to like just listen to what we have to say and everything.
Great. Well, I want to offer you guys a round of applause for an excellent job well done today. That is going to conclude your hearing. So I'm going to go ahead and stop